I've made videos about various kinds of contract clauses that you'll see in indie film related agreements, but I think it might be useful to make a video that deals with all of the provisions that you'll see in a specific type of agreement. For instance, an actor agreement or a crew agreement or a script option agreement and so forth. Today, I want to talk about one of the most basic building blocks of an indie film, which is the actor agreement or the talent agreement. In other words, the agreement that you, the production company, use to hire an actor to perform in your film. If you work on indie film for a while, you'll see a lot of variations on this type of contract. You might see contracts where the actors are awarded a share of the profits from the film. You might see clauses where the actors agree to shout out the film on social media and go to festival appearances. You might see clauses that talk about the dimensions of the trailer and the number of bottles of champagne or water or whatever that are going to be in it, and so on. But in this video, I'm going to deal with the fundamentals. I'm going to deal with the bare essentials of what you need, in my opinion, from a legal perspective, in a contract with an actor. But first, of course, a couple of disclaimers because, I'm a lawyer and we lawyers just can't resist disclaiming things. First of all, this is not legal advice, of course. If I were going to give you legal advice, I would need to understand the specifics of your situation and your specific needs. And right now, I'm just a lawyer talking to you on the internet. Second, I'll be talking primarily in terms of U.S. law. So if you're shooting your film outside the United States or your production company is located outside the United States, there are probably other types of contract provisions that you're going to need to have that aren't going to be talked about in this video. Finally, you should be aware that there are other documents that you're going to need to have your actors sign in addition to the type of talent contract that we talk about here. For example, if you're operating under the SAG micro-budget agreement, you're going to need to have your actors sign something called the SAG micro-budget acknowledgement, where that notes, for instance, that the actor's participation in the film is not going to qualify them for SAG-AFTRA membership. Also, because actors are typically treated as W-2 employees under U.S. law, you'll need to have them sign a Form W-4, which deals with the withholding of a portion of their income for tax purposes by the production company. And you'll find that on the IRS's website. But anyway, there are other types of forms that the actor is going to need to sign in addition to just the actor agreement. Finally, before we start, if you find this video helpful, please remember to like the video and subscribe to the channel so I can keep providing this kind of educational content to enterprising filmmakers like yourself. So with all that being said, let's look at the basic provisions of a talent agreement. What's the core of what you need in one of these actor agreements? And we'll be looking at an agreement that I drafted, but of course I've taken out the names to protect the guilty and to create a generic contract that we can look at together. So what we see in the beginning of this contract are what are called recitals, or these whereas clauses that you'll tend to see in the beginning of contracts. These tend to be viewed as non-binding by courts, although they are sometimes used to define terms that appear later in the agreement. It's not strictly necessary to have whereas clauses, but I use them to define the basic terms used in the agreement and to make clear what the purpose of the agreement is to someone who's reading it for the first time. In this case, the purpose of it is for the production company to hire an actor to appear in the film. Let's next look at the payment terms clause and look at Section A here, which talks about services to be performed. You'll see that I'm not very specific about the services the actor will perform during principal photography. I just say that they'll do the customary services that an actor would do in the context of a film. This is because it's difficult to define everything an actor does as part of their job. You could say they pretend to be someone else, but that's probably overly simplistic. I mean, they'll also interact with other actors. They'll shoot the same scene from different angles. They'll spend a long time waiting for camera and lighting setups to happen between shots, and so on and on. So in my opinion, you want to keep the definition of the services that the actor is performing as broad as possible so that there's no controversy about what specifically the actor agreed to do. I mean, it's rare in the context of independent film for an actor to say, well, I didn't specifically agree to do this or that in my contract. That is, unless we were talking about stunts or nudity or something like that, which you should definitely cover in the contract if that's something that you want in your film. But of course, the reason that we have these contracts is to deal with situations where people turn out to be unexpectedly hostile or crazy. Then, of course, you want to specify the dates of the shoot to make sure that everyone is on the same page about what schedule you're shooting on. Or alternatively, if there's some kind of uncertainty about when the exact dates of the shoot are going to be, you could say on dates to be mutually agreed upon by company and performer. That is in the area where I have that date highlighted and in bold. Now let's talk about payment, Section B. The first sentence is pretty straightforward. I say that the actor will get $206 a day. One note here, if you're dealing with inexperienced talent, It may also be useful to define what exactly a day means. As you know, if you've been involved in indie film, a day on the set of an independent film is usually about 12 hours. To avoid any dispute about how long the actor is supposed to stay on set, you may want to make that clear in your contract. The second sentence is supposed to make clear that if the production company wants to hire a payroll company that's going to make payments to the actors, in addition to calculating the amounts that need to be withheld for tax purposes and so forth, the production company is free to do that. That way the actor can't claim later on that because they got paid by the payroll company and not the production company directly, the production company didn't really pay them. Unfortunately, I've actually seen this happen, when in a particularly sour relationship that happened between a production company and an actor, although again, this kind of thing is thankfully pretty rare. The final sentence here is meant to account for the possibility that you'll need to do some post-production work with the actor, like for instance, ADR or automated dialogue replacement. Because the tasks like that, particularly in the context of a short film, probably won't require 12-hour days, it doesn't necessarily make sense to pay the actor at the day rate that they'd get for being on set. So in a low-budget indie film, I'll leave open the possibility that the production company can negotiate an hourly rate with the actor for any post-production work that might be needed. Now let's talk about legal compliance. The purpose of this paragraph is to make clear to the actor that the production company is going to withhold some part of the actor's pay for tax purposes, so this doesn't end up coming as a nasty surprise. U.S. employment law typically treats actors as employees rather than as independent contractors because for the time that they spend on set, all of the things that they do are being directed by the production company, specifically by the director who's been hired by the production company to direct the film. That means, among other things, that you're going to have to withhold income taxes from the paychecks that you give to the actors and pay the money to the IRS and whatever state you happen to be located in. Next, let's talk about the clause that has to do with credit. Ideally, as the production company, you're going to want to have the most flexibility possible in deciding how credits are going to be shown. If you're editing the film and you think that having opening titles is slowing down the pacing, it will be disappointing if you look back at the contracts you signed with your actors and they all say that the actors all need to be mentioned in the opening credits and each of them needs to get a separate title card and so forth. Having a credit clause that says that the production company has discretion over how credits are going to be displayed is the best way to avoid problems like that. Now, of course, you may be dealing with an actor who has enough bargaining power to allow them to demand restrictions on how they're going to be credited in the film. They may require you, like I talked about, to give them a separate card in the opening titles. They might require you to agree that no other actor is going to receive more prominent placement in the credits than them, a so-called most favored nation clause. They may require you to use special language in the credits, like with Joe the actor or featuring Joe the actor. So you may not be able to get the maximum possible amount of flexibility regarding how the credits are going to be shown, but I think it's worth trying to negotiate for and to give the actor or their representation a first draft that gives you that flexibility. Now let's talk about name and likeness. You've probably seen this kind of clause before. It's a probably unnecessarily long clause that says that you can use the actor's name, image, voice, likeness, and biography in the film in any and all media, in perpetuity, et cetera, et cetera. I think the important thing to notice about the way I've drafted this clause is that, like the credit clause we looked at a moment ago, it gives the production company the maximum possible flexibility in using the footage of the actor that it shot. So there are no restrictions on how you can use the image, likeness, and so on of the actor as long as the use has to do with the film, whether we're talking about the film itself or promotional materials like a trailer or poster or soundtrack cover or DVD cover or whatever. That's, again, what you would have in an ideal world. But again, you might be dealing with an actor who has the bargaining power to demand some restrictions on how their image and likeness is going to be used. They may say, for example, that if you're going to use their biography in promotional materials for the film, the biography needs to be provided by the actor or it needs to be specifically approved by them. They may want a separate clause relating to merchandising rights that gives them some percentage of merchandise-related profits in exchange for the right to use their image or likeness on T-shirts or action figures or whatever kind of merchandise you have the high-quality problem of being able to sell to people. If you do end up working with an actor who has the clout to be able to make demands like this, using changes to the image and likeness clause as a bargaining chip can be an effective way to negotiate. For example, say that you're trying to bargain for a lower rate of pay so that you can get a name actor within your indie film budget. If you want to do that, you can offer various restrictions on the use of their image and likeness in return for the reduction in the rate of pay that you're looking for. If all you give up is a restriction on the use of the image or likeness, that's not a very big concession in return for making sure that you can hire the actor within your budget. And that's a general rule that I think can be applied to any kind of negotiation. Try to give up something unimportant to get something that is important to you. Now let's talk about the work made for hire clause. It's very important to have a clause making clear that any work the actor does for your production is, quote unquote, for hire for intellectual property purposes. This type of clause makes clear that the only thing the actor is getting for their services is the payment you agree to make to them. In other words, they don't get any intellectual property rights associated with the film. This clause is meant to eliminate any possibility that the actor can come back and claim that because they made some kind of creative contribution to your film, they should therefore be considered a co-author of the film for copyright purposes. And if someone is a co-author of the film for copyright purposes, that means that they get the right to have an equal share of the profits with all of the other authors, which of course would be a bad thing for you if you're the filmmaker or the production company. You'll see that in addition to saying that the actor's performance is considered a work made for hire in Section A, I go on to say in Section B that if the actor's work is found for whatever reason not to be a work made for hire, the actor nonetheless is transferring all of their intellectual property rights associated with the film to the production company. This is meant as a backstop in the event that a court, for whatever strange reason, decides not to enforce the work made for hire clause. That would be unlikely, but weirder things have happened in the U.S. court system. Having this kind of clause is going to be important to a distributor in case you want to work with a distributor, which I think most independent filmmakers do, and so it's going to be a must-have clause for all of your cast and crew. Now let's talk about the next clause, assignability. This simply says that the production company can assign any of its rights under this agreement in its discretion. Under the law of most U.S. states, you don't technically need a clause like this because a party to a contract is usually assumed to be able to assign its rights under the agreement unless the agreement specifically says otherwise. However, it almost never hurts to have extra clarity in a contract. The purpose of this clause is usually to make sure that you can assign any of the rights that are discussed in the agreement to a distributor if you're fortunate enough to get hooked up with the distributor for your film. Or maybe you want to form another production company and have it acquire the rights associated with your film. Say, for instance, if you want to shift from doing business as an LLC to doing business as a C corporation or an INC, which sometimes production companies want to do. Now let's look at the entire agreement clause. This is a standard clause saying that the written agreement you're looking at represents the entire agreement between the parties, and it supersedes any other discussions or negotiations the parties may have done. The purpose of this clause is to make sure that the actor can't argue that you agreed to terms that are different from those in the written agreement, say when you're having phone conversations with their representative or you're exchanging emails with them. Let's say, for example, that you have a conversation with an actor's representative, like their manager via text, where he says, "Can you do 10K?" And you say, "That might work," or something, brief like that. But later on, you enter into a written contract with the actor that says that you're going to pay them $5,000. Then, of course, after the shoot is complete and you pay the $5,000 that the actor is owed, the manager comes back and says, "Wait a second, you agreed to 10K. We talked about it over text." This kind of clause is meant to stop those kind of shenanigans, because if the actor takes you to court, if the actor files a lawsuit against you, then you can simply show the court this clause, which says, this agreement supersedes any of our prior negotiations, and then show them the provision of the agreement that says that the actor is going to be paid $5,000. And then the manager won't be able to argue based on your prior communications that you agreed to a higher rate. Next, let's talk about termination. This is pretty self-explanatory. Either party can terminate the agreement effective immediately, and the actor will get paid anything they're owed if that happens. Something that you may not be as familiar with here is the survival clause. That is the part saying that sections 2, 3, 4, and 8 shall survive the termination of this agreement. That means that even in the event of termination, it'll be as if the parties continue to agree to those specific provisions. What are those provisions again? Those were the provisions that dealt with credit, name and likeness, work made for hire, and governing law. If I'm the filmmaker, the reason I want those provisions to survive is that I want to have the maximum flexibility possible to use the footage that I shot of an actor who happens to quit in the middle of the production or happens to get fired in the middle of the production. Let's suppose, for example, that I have an actor in my independent film who quits, but I got a really good shot of them from the back in my film. And I think that I can recast another actor in that role who looks fairly similar to the original actor from the back. And I don't want to pay, the cast and crew to come back and reshoot that particular shot that I'm talking about. If I retain the right to use the image and likeness of the actor who quit in my film, then I may simply be able to use that shot and not have to go back and do an expensive reshoot, which of course can be very problematic if you're operating on a low indie film budget. Next, let's talk about governing law. The goal of Section A of this clause is to make sure that if, again, heaven forbid, there's a dispute between you and the actor that ends up in court, the parties have to litigate in a court that's convenient for you. So if you happen to live, as I do, in California, you'll probably want to select courts located in the state of California, and perhaps in some specific part of California, like Los Angeles. Courts usually do enforce these requirements, which are normally referred to as forum selection clauses. You'll notice that the clause also says that this agreement shall be governed by the laws of the state of California. That means that no matter where the events that are relevant to the lawsuit happened, the court hearing the dispute is always going to apply California law. This is important because courts tend to apply the law of the place where the relevant events happened. Say, for example, that you sign a contract with this clause with an actor in your independent film, and you shoot the independent film in Mexico. Then you're shooting in Mexico, and the actor gets food poisoning from eating catering that your production company orders, and he sues you for negligently hiring the caterer. Ordinarily, the law of Mexico, where the food poisoning took place, would apply. But if you have a clause like this, which is called the choice of law clause, that selects, in this case, the law of the state of California, then a court that's hearing the dispute will not apply Mexican law, but will apply California law. And that's going to be particularly useful to you if you're based in the United States, because US-based lawyers don't tend to know very much about Mexican law. And so if you wanted to deal with Mexican law, you'd probably have to hire Mexican lawyers in addition to your American ones, and that would pile expenses upon expenses. And that's, again, not something that you want as an independent filmmaker. Now, let's look at Section B, performers' remedies. This is a so-called no injunctive relief clause. The purpose of this clause is to say that even assuming the actor has some legitimate claim against the production company, the only remedy that the actor can get from a court is damages, that is, money. The actor can't get what's called an injunction, or an order that in some way prevents or limits the screening of the film. So, for example, if a dispute comes up with an actor about how much they were going to be paid for your shoot, and it actually gets to the point where the actor files a lawsuit, the actor won't be able to get an order from the court stopping you from screening the film until you pay the full amount that the actor claims that they're owed, which of course would be disastrous for you. The best the actor can do is to get you to pay them money if the court agrees with them that the amount they claim to be owed is correct. Distributors often explicitly say in their contracts with you that you have to have this type of clause in the agreements that you sign with your cast and crew. So you definitely want to have a provision like this one. So those are all of the contract provisions that I think, at a bare minimum, it's important to have in the contracts that you sign with the talent who appear in your indie film. Of course, like I said, many talent agreements contain a lot of additional language having to do with all kinds of issues, like what kind of hotel the actor is going to stay in, what size their name needs to be relative to other actors' names in posters or the credits or something like that, whether the actor is going to share in the profits and so forth. But the language that I've listed is, in my opinion, the bare minimum of what you need to have an effective talent contract. I hope that you found this helpful, and thanks for watching.